Okay, People of the State of Michigan versus Cornelius Jackson, docket number 20-82FH. And this was the time set for a pretrial. I'm informed that it will be a plea, is that correct?
That's my understanding, yes, Your Honor.
Mr. Berry, okay. Let me just find my information. Okay, so is this a plea to the charge?
Yes, Your
Okay.
Honor.
And Mr. Jackson, I received a form that you had signed that shows your address on Hunter's Ridge. Is that your current address?
Yes, Your Honor.
Okay, and do you work right now?
Yes, at Denny on
Uh-huh.
Saginaw Highway.
Okay. Would you raise your right hand, please?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Jackson, you have the right to be represented by an attorney. You are represented by Mr. Berry, and Mr. Berry informs me that this is a plea to the charge. Would you read that, please, Ms. Allen?
In the People of the State of Michigan versus Cornelius Jackson, file 20-8-FH, State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about January 7th, 2020, at 500 East Edgewood Boulevard, City of Lansing, Ingham County, the defendant did in count 1, while targeting open to the public, steal property of the store that was offered for a price of $200 or more, but less than $1,000. And it further appearing that on April 22nd, 2010, said defendant was previously convicted of violating retail fraud first degree, contrary to Michigan law in the 56th Circuit Court in Eaton County. Therefore, this violation of Michigan law constitutes retail fraud in the first degree, contrary to Michigan law. This is a felony punishable by 5 years and or $10,000 or 3 times the value or difference in price of the property stolen, obtained, or attempted to be obtained, whichever is greater. To impose that fine of 3 times the value, the defendant must admit the amount or it must be determined by the trier of fact at trial. The court may order reimbursement to state or local government for expenses in relation to the incident, including but not limited to expenses for emergency response and prosecution, and was committed against the peace and dignity of the state of Michigan.
Mr. Jackson, you're being charged here with first-degree retail fraud. That is a felony punishable by up to 5 years in prison. Have you had enough time to talk about this charge with your attorney?
I have.
And do you understand the charge against you?
Yes, I do.
Do you have any questions about what we're doing?
Not thus far.
Okay, how do you want to plead?
Well, I guess now I got a question. So, I had.
Mr. Jackson, we'll state the complete plea agreement on the record. We
Okay.
will do that
Yeah.
afterwards.
Okay,
I'm told you want to plead guilty. Is that correct, Mr. Jackson?
that is correct.
All right. If your plea of guilty is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with a trial. There is a form here that lists those rights, and it looks like it has your signature on it. Did you sign the form?
I did.
Okay, so you went over the rights with your lawyer,
Yes, I did.
and you know that if you plead guilty, you give up those rights,
Correct.
and that's what you want to do?
Yes, Your Honor.
Also, if I accept your plea, it means you can't come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Correct.
It also means you cannot come back later on and try to say that it really wasn't your own choice to plead guilty today. Do you understand that?
Yes, Your Honor.
Is there a plea agreement, Ms. Allen?
Yes, Your Honor. In exchange for the defendant's successful plea and sentence to count 1 on this file, we agree not to issue 4 pending cases we have at the Ingham County Prosecutor's Office. And just for the record, they are 20-382, 20-383, 20-385, and 20-958. The defendant agrees to pay restitution on all those files, including this one. The total amount, Your Honor, is $767.67 to Target. There is also a sentence agreement pursuant to People versus Killebrew that the defendant's upfront jail will not exceed 12 months in the Ingham County Jail.
Mr. Berry, is that a full and complete statement?
It is, Your Honor.
Mr. Jackson, is that your understanding of the agreement?
Yes, Your Honor. I just got a question to the prosecution. Is one of the cases the one for East Lansing?
Yes, I believe it's all the ones we have at our office. I think the East Lansing one is one of those.
Correct. Okay. Yeah, that's okay. Yes, Your Honor.
Okay, so you agree with this?
Yes, Your Honor.
Okay. There is an agreement about your sentence, and that is that it would be no more than 12 months in jail. If for some reason I decided not to go along with that, I would tell you before I sentenced you, and I'd give you a chance if you wanted to take back this plea and start all over. You got that?
Yes, Your Honor.
Has anyone promised you anything else that hasn't been said here right now in order to get you to plead guilty?
No, Your Honor.
Anyone used any threats?
No.
Is it your own choice to plead guilty?
Yes, it is.
And are you doing that because you believe you are in fact guilty of this offense?
Yes, Your Honor.
Tell me then what you did on or about January 7, 2020.
Me and my co-defendant, Mr. Baldwin, went into Target, and we stole some, I believe it was some alcohol, some kitchen appliances,
Okay.
and took them from the store.
And was Target open to the public at the time?
Yes, Your Honor.
And were these items that you stole merchandise that they were offering for sale?
Yes, Your Honor.
Did you actually remove them from the store, or did you get stopped?
We got stopped in the parking lot of Applebee's.
Okay, but you had gotten the merchandise out of the store,
That's correct.
and you were intending to steal it had you not been caught.
That's correct.
Okay, and that was the Target on at 500 East Edgewood in Lansing, Ingham County, is that correct?
Yes, Your Honor.
And was the property that you stole offered for sale at more than $200?
Yes, Your Honor.
All right. Has the court complied with MCR 6.302, Ms. Allen?
Yes, Your Honor.
Mr. Berry?
The court has, Your Honor. However, just so that we don't run into any issues, may I ask a follow-up question of Mr. Jackson?
Sure.
Mr. Jackson, this incident that you're pleading guilty to is in reference to January 7th. That police report indicates that you had taken you and your co-defendant had taken a kitchen mixer and a Ninja blender. It doesn't reference any alcohol. So is this the occasion? Do you remember that occasion? And did you take those two items with Mr. Baldwin?
That is correct. I
Okay.
was referring to the file she had stated that's still pending.
I understand. Just for factual basis for this particular incident, was those two items though, correct? Okay, thank you. And I have no further questions, Your Honor. Thank you.
Okay. Are you aware of any promises, threats, or inducements other than those already placed on the record, Ms. Allen?
No, Your Honor.
Mr. Berry?
No, Your Honor.
The court finds the plea is understandingly and voluntarily made without undue influence, threats, or promises of leniency. It is an accurate plea. It's supported by the testimony. The plea is accepted. I have a sentencing date of Monday, September 14th at 2:15. Does that work for you, Mr. Berry?
Well, Your Honor, if I may, Mr. Jackson is scheduled for a sentencing in Eaton County on a probation violation on September 17th. We would ask the court if we could have this scheduled after September 17th.
Sure. Let me just get a date.
If the court is open, I can do the 18th if the court is open.
Oh. Did you hear that?
Yeah, the 21st at 2.
September 21st at 2 o'clock. How does that sound?
That'll
I'll make
work.
that work, Your Honor.
Okay, I think that what I'll do is, I don't know what I'm gonna do at sentencing, but I can work around whatever the sentence may be. So I think that what we'll do is, if your client consents, plan a Zoom sentencing, if that's okay with you, Mr. Berry.
Yes, Your Honor. We think there's a possibility he may be in custody at that time with Eaton County, and so I'll let your
Okay.
court staff know, and I'll also be asking when I do learn of that, if it happens, that we will revoke his bond at that time, so he gets credit for those days, if it
Perfect.
happens.
Perfect, okay. Then September 21st at 2 o'clock, and Mr. Jackson, that obviously if you're in custody, we'll get you remotely, and if you're not, then we'll need to have you Zoom in again, just like you did today, okay?
Not a problem, Your Honor.
Okay, great, your bond is continued, and you are all set. We'll see you on the 21st.
And
Thank
that was
you.
at 2 o'clock, Your Honor.
Yes,
Thank you. Have a good day, Your Honor.
thank you, you too.
Sorry I didn't get to you in time. Eaton County only does 3 o'clock. So
Oh,
if he's in Eaton County, I'll
We'll
leave the
fix
3
it.
o'clock
Yeah,
spot
yeah.
available just for that.
no problem. Let's see, this would be Alish, Ken Marks.
Afternoon, Judge.
Hi, hang on, I muted your client at the jail, and now it's always a challenge to unmute him. There it goes, okay.
Okay.
All right, this is People of the State of Michigan versus Cornelia Smith, docket number 20-328FH, and this is the time set for hearing on the defendant's motion to modify bond. Mr. Smith is with us from the jail remotely, and Mr. Marks for Mr. Smith, and Ms. Gallagher for the people. Go ahead, Mr. Marks.
Thank you, Your Honor. May it please the court. As the court has already stated, before the court is a motion to modify bond. And I do want to let the court know that I did receive the recommendation as far as from the pretrial service investigator. There is one correction or addition I'd like to put with that. My client was arraigned this morning before Judge Alderson on the DV third as a third habitual. The bond on that matter is was put at $10,000 cash surety. With that in mind, Your Honor, the motion that I put before the court requested as far as consideration for a bond of $25,000 cash surety. My client has asked me to ask of the court for a personal recognizance bond. But I would argue that in the alternative, if the court decides not to go with a personal recognizance bond, I would ask the court for a $15,000 cash surety. With that, that will bring his total bonds out there. Well, really, it's going to be more than $25,000 because he also has a $1,500 on a retail fraud out of 55th District Court. And just to continue with that, as far as the reasoning behind lowering the bond, it is my understanding, in speaking with my client, also with Deputy O'Neill out at the Ingham County Jail, that for my client to be considered for any type of work status, his bond has to be less than 20,000 for even to be considered.
I thought the amount was 10,000 for work status, but if that's what they told you.
Well, I'll go with the 10,000 then.
I'm not saying I'm giving it, I'm just saying I think that's what you need for work status. It always was the rule, but,
It is
Okay.
10,000.
so your client and I are in agreement, it is.
Yes, the two of you are.
Okay, anything further, Mr. Marks?
No, Your Honor, thank you.
All right, Ms. Gallagher?
Thank you, Your Honor. I did file a response, but just to highlight the people's position that this defendant is a very dangerous person to the community and to the victim in the case. I think that the documented history of domestic violence is very, very numerous, along with the undocumented history. Further, the charges at hand and the violations that have already he's already found guilty of are really indicators that the people's position is that the bond set as is pretty low. And so we would respectfully request the court not modify bond.
All right, thank you. Well, this isn't a 180-day issue or anything like that. Mr. Smith has been in on this case for about 74 days. It's just a request to lower his bond, or as he's requesting, a PR bond. The prosecutor did file a response, laid out extensive facts. Any one of them by themselves would be enough for me to deny this motion. Taken all together, they are more than ample. He has multiple felony warrant requests that are under review at the prosecutor's office. Here's the one that by itself would be enough. He was found guilty of violating the no contact order 3 times on February 4th, May 8th, and May 20th. The alleged victim has expressed fear of him, and he has, according to pretrial services, prior convictions for assault, GBH, domestic assault and battery, 3rd offense, multiple drug offenses, resisting and obstructing, operating while intoxicated, and they also indicated that he has 2 bench warrants out of 54A and 55th district courts. So I am denying any request to modify, lower his bond, or give him a PR bond. And that will conclude our hearing. Mr. Mark?